And the first agenda item is listed as discussion and possible recommendations on changing the ethics policy. And our last meeting, we did discuss this and asked the town clerk to invite Kevin Delaney and town council Jeff DiNaprio, who are both signed into this meeting. So welcome, Kevin and Jeff. So we had some specific questions which the town clerk may have run by you. I think the biggest question we wanted answered, Kevin, if you're able to, is this new, well, a few years ago, this newly implemented ethics policy included the submission by certain town employees of a financial interest statement, which is some unions have allowed, or maybe none of them have. There's been some pushback from the town unions, or the unions covering town departments, on compliance, and then just other sporadic, failure to comply with the disclosure requirement that the town clerk has to then deal with. So our question was, this came about, this addition to the ethics policy, during a town audit, and I believe it was recommended by the auditors and the finance director at the time, recommended that this particular disclosure requirement be included. So our question is, will that negatively affect the town in any way if we recommend to the town council that section be deleted, that there's no longer a requirement for a financial disclosure statement from certain town employees?
I did speak with our auditors, and their basic take on it is, number one, what we're doing is best practice, and it is what we really should be doing. They focus most of their attention on the elected and appointed officials, more so than the staff. But they did say, to the extent that anybody in staff, and by staff they would refer to everybody from town manager down, who is in a position to make a purchasing decision, really should provide a disclosure where there might be a conflict of interest or where they might have a personal vested interest. One of the objections I know that I've heard from union members has been that the current documentation requires disclosure of everything. For example, I have to disclose if my wife is employed and where she's employed, even if it has absolutely no bearing on town business. So what they did share with me is, in many of their client communities, they have a similar disclosure, but it's specifically tied to areas where there is or might be a good chance of a conflict. So, for example, Anthem is the insurance carrier for the town. If my wife is employed at Anthem, I should disclose that. I can also disclose that she's, a claims analyst who would have nothing to do with our business, as opposed to she's a small mid-market underwriter and might very well have our business. Those types of things. And they said it's really geared more towards disclosing those elements. And from a staff standpoint, it's really geared more towards those who have the authority to make decisions. So, for example, purchasing decisions up to $10,000 are, between $2,500 and $10,000 need to go out and either get quotes or bids. However, that can be exempted by the town manager. So town manager would be one where they would say, you could be in a position to make a decision where you have a personal interest in that. Somebody, a junior analyst on my team, wouldn't have to disclose anything because they're not in a position right now to have that decision authority. They did focus mostly on the elected and appointed officials, as I mentioned, because most of our purchasing decisions, especially the real substantial ones, have to go before the council. There may be other financial decisions to the Board of Finance. You could have tax abatements with the Economic Development Commission. So they kind of focused on those areas. It would probably not be viewed. The impression I got from them was not that they were suddenly going to, I don't know how to put it other than, hammer the town in an audit opinion, but they probably would say that it is a good idea to have that and have that disclosure. One thing I will say that, just to add on to that, and then I'll stop, is the question they asked is, what do you do with this? So is it reviewed when you go before the council to make a decision? Are you reviewing the 7 members of the council if there's a potential conflict? If staff is coming forward with something, is there a potential conflict? And I'm not really sure anybody does that extensively, because that would be a pretty onerous undertaking to review every single item that comes forward. Some of it you have to rely on the elected officials to operate properly.
Yeah, and I know that the town charter and the ethics policy require certain individuals to make those disclosures if something comes up during the course of a meeting or any other thing that they're going to be reviewing or weighing in on, that they have a conflict of interest, as defined by the Code of Ethics. They have an obligation to put that in writing to the town clerk. So that safeguard exists already. To the extent people do that, I have no idea. But it's definitely a requirement already. And the financial disclosure statement is just an additional requirement for something that already has to be disclosed if a conflict arises. Maybe others on this line know this, but I don't. What's the significance of an audit for our town? How often does that occur? And what is there a rating to it, and what does it mean?
We are audited annually. We are required by state statute as well as by charter to produce a financial report and have that report audited by December 31st each year. If we didn't have an audit done, well, if we had an audit and there were a modified opinion, so basically not a clean opinion, that would be viewed very unfavorably. That would be highly unusual. Typically, the auditors would bring forward an issue and the town would address whatever the issue is. To go out with anything other than a clean opinion would be something that you couldn't reconcile. It's just not. We would do everything possible to avoid that. Currently, the town has a AAA bond rating. That certainly would be adversely impacted by anything other than an unmodified opinion. The town also obtains, in a professional circle, government financial officers issue an award every year for communities to apply for the quality of their audit reporting. The town, as of fiscal year 19, we're just finishing the audit of 20 now. Through fiscal year 19, the town has received that award for the last 34 years. So it would be a pretty significant negative if there were unfavorable action in the audit.
And in your opinion, would removing the financial disclosure statement from the ethics policy give rise to anything other than, a clear rating?
No, I don't see the auditors modifying their opinion because of that. They probably would include it in a management letter recommending. But I can't imagine that would rise. The auditors don't want to offer that opinion. Typically, they only offer that if there is an extreme case, and I don't see that rising to a level of warranting a modified opinion.
And I'm just one more, Jeff, and then I'll let other members of the committee weigh in. Do you expect that if the, I guess, group of people that is sort of required to submit the financial statement, in other words, to Kevin's point, if it's just elected officials and people with a purchasing power of a certain degree, which to some degree that's what the policy is now, but if it's further restricted, do you think that will in any way satisfy the union's unwillingness to submit these financial statements, or would it just be like, hey, we're still not doing it?
I would expect that they won't do it because they look at it as something that needs to be bargained for in collective bargaining. There's certainly value to it from the town's perspective because, as you indicated, on the one hand, the obligation to disclose a conflict of interest is there, and the financial disclosure is just a snapshot in time, right? The date that it's filled out, it reflects personal circumstances. One of the reasons why auditors recommend it is because individuals don't necessarily know every vendor the town is doing business with, and most don't. So by having that disclosure, Kevin brought up the disclosure as to a spouse. It's not because we're looking to invade anybody's privacy, but you may not know what we're planning or what we're doing with every vendor. So having that disclosure is a benefit to the town. But like you said, there's an obligation to make that disclosure under the code and under the policy of a conflict of interest anyway. But to answer your question, I don't think it would make a difference to the bargaining units, because I think the union reps are just telling them, look, this is something that's not bargained for. We don't have to do it. Especially with the police union, they feel that they have their own code of ethics, and therefore they don't have any concern about having to comply with the ethics policy, because they've already agreed that they'll comply with their own internal policy.
Right, and we did, the town council did accept our recommendation a couple years ago to exempt the police union from having to provide these disclosures.
That's right.
Sue, Nina, or Anne Marie, do you have any questions for these guys?
Now, my only concern, I was talking to somebody this weekend who obviously is part of a union and happened to know that I was on the ethics committee. She had said that they were told by their bargaining units or their unions to just sign it under duress if they absolutely had to. And so I don't even know how we would enforce that anyway. So is there some way to just exempt these unions if this is such an issue? Or I'm not sure how we would handle this.
Well, I mean, look, the reality is that the code of ethics and the ethics policy are applicable to all government officials, elected or appointed, and town employees. That's by charter and that's by policy, and it's consistent with the Connecticut general statutes that authorize municipalities to enact codes of ethics. So whether they sign or not, they're subject to it, unless there's a specific exemption like there was with the police union. And in terms of duress, I mean, I'm sure Kevin understands this. The duress is not, we want you to sign it, you don't want to sign it, you sign it. So I'm not worried about enforceability of someone signing it. No one's literally putting a gun to their head. So it's not real duress, as that term is considered by Connecticut case law in this context. But the reality is that, they need to be aware of what the policy says, and not signing it if there's a conflict of interest that's not disclosed, or somebody misuses confidential information, or somebody misuses their position. The fact that they didn't sign it is not going to be a valid defense to an ethics complaint.
Would there be any consideration to providing the ethics policy and putting a note or a disclosure that they have to sign, which says they've read the ethics policy, they understand that failing to comply with it can result in action up to and including termination of employment? I'm talking for the union folks. Then it wouldn't require them to disclose everything, but it would make them aware that you've read the policy, you understand that if you have a conflict of interest, you need to disclose that and recuse yourself. And if you don't, action can be taken up to and including termination. I don't know how it would fly with union contracts, but it would seem like if someone, I'm talking staff here at this point, if staff misuse their position, either because they're a liaison to somebody and then they misuse their position for personal gain, that seems like a pretty serious violation of what we would expect as sort of minimum ethics standards for anybody employed. You don't necessarily have to call out. It's a recognition that if we become aware of it, it's grounds for action up to and including termination.
Yeah, I mean, look, there's two separate paths, right? I mean, if there's a violation or an alleged violation of the code or the policy, someone can file a complaint, and the Ethics Commission has the jurisdiction afforded to them by the code and the policy. In terms of employment action, the Ethics Commission doesn't have jurisdiction to terminate. That's the town manager's responsibility. So certainly, if somebody violates the ethics policy or the code of ethics, that's something that the HR director and the town manager and that person's immediate supervisor would have to take into consideration, subject to the process, if they're a bargaining unit employee, subject to the rights that they have under their collective bargaining agreement. So, certainly those ethics policy or not, signing it or not, there's certainly rights that the employer has under state law. So those are separate.
Kate, when the financial disclosure form is mailed out every year, a copy of the ethics policy goes with it, right?
Yes.
And is there any signature requirement to say, hey, I received this?
As far as on the disclosure,
Right, or otherwise?
yes, they also receive the acknowledgement. So there's what they call Exhibit A, which is saying that they received the ethics policy, and then the fact that they complete the financial statement says that they saw it.
So Nina, Sue, and Anne Marie, my thought is the cleanest way to deal with this would be a recommendation to the town council that the financial disclosure statement, go away, that's not a requirement anymore. I don't know, I'm not saying that we should make that recommendation. I'm just saying that's the cleanest way to do this. The problems with having the financial disclosure statement are that it's going to set up litigation for the town when unions tell their members not to comply. And if somebody makes a complaint that there's no compliance, and now we have the Board of Ethics, administrative process gets put into place and we have to have these hearings, these people are going to come with lawyers, rightfully so, because they feel that they're not required to do this. And that'll set up some litigation. Maybe the town council wants it. Maybe that's what the town wants, is to litigate this to get an answer to it. I doubt that, but that's the town council's decision. But that's kind of where this gets set up to go, in my opinion, if this requirement persists. So we're weighing that versus an auditor telling the town each year, hey, we know you got rid of this, you should really have it, and does that really negatively impact the town or not? So that's sort of, a prediction of the future of where this could go. So, I don't know, any thoughts by the three of you as to, that sort of feedback, or any other suggestions or input?
Kevin, I'm going to unmute everyone because I have a caller number 2 that is muted, and I think it's Sue. So I'm going to unmute everybody.
Okay.
And then I'm going to start muting you, only so that to make sure everybody can speak. I'm still not unmuted.
Hello?
Hi, Nina.
Hi. So, Kevin, what am I understanding? That you want to eliminate the statement of financial interest completely, or just that paragraph? What is it, number 3?
I'm sorry, what are you looking at, Sue?
No, I'm Nina.
I'm sorry, Nina. Are you looking at the ethics policy or the town charter?
I'm looking at the statement. You mentioned something about eliminating the statement of financial interest. That form that needs to be filled out.
Yeah, so that would be section 1-10 of the Board of Ethics policy. I'm sorry, of the ethics policy.
Okay.
And I'm not necessarily suggesting that we make that recommendation. I'm just saying that is the cleanest way to handle the issues that have come up. Another way is, Kevin Delaney's telling us that best practices is to have this disclosure requirement, and we know that surrounding towns require it. And we could let the chips fall where they may and say, our recommendation is don't change the policy. Let's see how people comply with it. And if there's any complaints, we're the Board of Ethics. We'll do what you appointed us to do. That's sort of the whole spectrum of both ends of the range of things we could recommend.
Okay. So we leave things as is then?
Is one
They have
option.
to- Go ahead.
I'm sorry, Nina, I cut you off. Go ahead.
No, that's okay. So you recommend that we leave things as is, that they have to sign for the receiving of the ethics policy annually, and they also have to file a Town of Berlin statement of financial interest, correct? We leave things as is then. Is that what you're recommending?
I'm not recommending that, Nina, and thanks for let me know that you need clarity of what I'm saying. I'm just saying that's one option. That's an option. And I think we all know that if that's the option, that there needs to be a clarification of the process of notice, because pursuant to our last meetings, the notice requirement seems ambiguous of what the town clerk has to do to notify, that second notice is not really meaningful to anyone in town who's getting this. It has a requirement to disclose, but does not. If we decide that our recommendation is, hey, you need to keep this policy in place, I think, fairness to town employees requires a clearer process by which they get that second notice that, hey, you haven't complied yet. And we know this year was a difficult year because of COVID, and the town offices weren't even open for many of the early weeks of the year there, where these things normally would be coming back.
Mm-hmm.
Just to clarify, it's not my recommendation. It's just one of the things we could recommend, and I'm definitely interested in what you all think.
Okay. And then, so basically, we have to find a way to enforce this then, correct? So that Kate receives all of the signatures and the statements of financial interest, correct? Because I think her problem was she couldn't enforce it, or the staff was telling, or some staff members were telling her, no, I don't want to submit this. So do we find a way to enforce this, or?
Yeah, I think the policy provides an enforcement mechanism that the board employs when a complaint is made, but the notice process seems to be lacking at this point. And yes, there are groups that just flat out say we're not complying with this, and then there's others who might just not get sufficient. They get the first notice, we think, because the town clerk is mailing out notification to everyone who's supposed to get this. I think we all probably recently received it. But then, if it doesn't come in, there's a second notice requirement, which seems to be insufficient in my opinion. It's basically the town clerk is tasked with a heavy task of going to each department head or manager and saying, hey, we didn't get this from 3 of your employees, or there's 4 people on your board or commission that haven't complied. And it's really tough to know whether they then get that second notice or not, because no one's really signing off on it. So that's go ahead.
Well, I think if you're employed or you're part of the either an elected member or you're part of the staff, and you've read the policies, of ethics, at some point it clearly says on section 1 through 6 that there could be a penalty of $1,000 and potentially a loss of a position, correct? If you don't comply to any of the yeah, to yeah, if you
Yeah,
don't
I
comply
think
to the correct?
I think you're right, Nina. There's a penalty phase at some point if there was notice and non-compliance. And I think again that's where we're likely setting up litigation for the town, is if you know we or whoever's on the Board of Ethics starts to get these complaints and start to you know have the hearings pursuant to the ethics policy, and that's when it'll come to a head. Is unions will say we don't feel they have the obligation to comply with this notice of disclosure because it wasn't collectively bargained for. I think that's what Jeff's telling us. Tell me if I'm wrong, Jeff.
No, you're correct. They would grieve it through their union process. You know, we depending on what the recommendation is from your commission to the council and how the council wants to proceed. Another way to address it would be to direct labor council for the town to, as each contract comes up for, you know, renegotiation, to make this a language issue, you know, that this is a requirement that we need to include in the town's collective bargaining agreements going forward.
Mm-hmm.
Have you seen that in other towns? Is that something that?
To be honest with you, I do a lot of municipal work, and I have for 30 years, and the codes of ethics have become much more common at the municipal level over the last 15 years or so. And this really doesn't come up in most towns. You know, either it gets signed, acknowledged, and it's not an issue, or people don't worry about it. Because I never, other than Berlin, I never really get this issue. I certainly have lots of ethics commission and board of ethics proceedings in other towns where there's complaints that have to be decided at all levels. But in terms of non-compliance with signing an acknowledgement of the receipt of the policy, that doesn't come up. And not every town requires the financial disclosure. I think as Kevin said, it's a best practice. It came about as a recommendation from an outside auditor, but not every town requires it. And I haven't seen it be material in terms of identified as a weakness or a problem in a auditor's letter.
Well, let me ask the other members of the board, Stu and Anne Marie.
Yeah.
So there's already the safeguard in the town charter and the ethics policy that anyone who's voting on or weighing in on, meaning possibly awarding a contract or doling out money on behalf of the town, or voting on a commission or, the town council, already has the obligation themselves to identify any, conflict of interest as defined by these two documents. Is that sufficient in our opinion, or do you think the financial disclosure, the town should still use that? And again, we're trying to just weigh the public confidence and that everything's on the up and up in our town by whoever's making the decisions versus, getting more information on people who are making the decisions, who already have the obligation to bring that up if it's implicated.
Well, from what it sounds like from Jeff, it's an obligation, and if they go against it, it's automatically going to be brought up against them, whether they sign off on the disclosures or not. So they're not going to be held accountable based on their signing of the disclosure. Like I said, if they've done something wrong, they're going to get, in trouble for it just at a base level. And it just sounds like it's more of a nightmare for the ethics committee to have people bring up the fact that they haven't signed the disclosures every single year like they're supposed to if they're part of the bargaining unit. So I'm with you. I think if they're just signing off saying that they've read the policy and it seems, that that's appropriate enough and it's not going to impact the town, then the disclosures will probably go away because there's we've decided more than half or at least close to half of them that aren't being filled out.
Right, exactly. And I mean, this issue may never come up ever.
Right.
We might just recommend they keep the policy the way they do and the town council agrees, and the town clerk will keep doing the best job she can with the rules that are in place, and maybe someone makes an issue of it, maybe someone doesn't. Not that we're trying to punt the issue, but it may never come up again. As Jeff said, it doesn't seem to be a common issue in other towns, but it does cause her a lot of tough work to be dealing with this from a manpower standpoint.
Chasing people down.
Sue, are you there? Sue, are you able to talk?
Yeah, I tried to see, but I was on mute.
Okay, go ahead. Yeah, go ahead.
Just wanted to weigh in. And I'm getting a lot of feedback, so sometimes it's hard for me to hear and understand people. So as far as the statement of financial interest, if I understand right, Kevin said that it's not going to really, if we drop that, it's not going to really hurt us, like from an audit point of view. But I tend to think that keeping it is better protection for the town, to be in the town's best interest to keep that. But I do hear that, the point that it is going to be a nightmare to follow through with all the steps of sending it out, making sure that people receive it and it's returned and, all that for the town clerk. And then also the fact that somebody may want to file a complaint because someone else did not sign it or return it. And, I understand from the attorney that even if they don't sign it and return it, that it's still enforceable. So we don't have to worry about that. It's just, I hear, Kevin, when you say that we could potentially get a lot of cases about people not signing it, which maybe most likely would be rare. So I'm kind of like torn on this, whether we should keep it or not, because I think there's pros and cons on both. But I do think it's in the best interest as far as protection for the town to have it. But if we do, I think we need to really give a lot of attention to the follow-up procedure, because right now there's no way of confirming the fact that someone who did not return it actually got it. So we have to make sure somebody gets it and have a follow-up procedure on there. We would have to look into that. So that's my feeling about the statement of financial interest. There is one other thing, though, I did want to mention. Kevin Delaney gave an example early on about like his wife being employed at an insurance company that the town uses, and that, you have to put these conflict of interest in writing. My question is, where is that section where somebody would put any conflict of interest down, like if their spouse is a town employee or whatever? Because anything that I see right now, and also the ethics policy refers to identifying these conflicts in the financial interest statement. But from all the questions in that financial interest statement has to do with corporations and businesses and contracts and things like that. So am I missing something here where there is a section that could be completed, or do we need to include that so someone can actually put in writing what the conflict is? So that's about all I got.
Well, wouldn't you put that under number 3, employer?
That's
No.
exactly where it's intended to go.
Well,
It's include name and address of the employer that you, your spouse, your dependent, corporation, trust,
Right.
partnership, which you, your spouse, yada yada, received at least 10,000. That's where I have to. That's where I disclose my wife's employment.
Okay, so we had a little discussion, Kevin Delaney, about this at our last meeting, and I even ran this whole number 3 by several other people, and what their interpretation of that was that this whole paragraph is talking about involvement with a corporation, a trust, or a partnership that you or your spouse or dependent is involved in, and having a 5% legal equitable interest and receiving 10,000 in earnings. So you know, it's asking for the names of employers that whether you're a joint recipient with your spouse. So when they're asking about employers, my interpretation is in regards to businesses and corporations, not that, you know, my wife works for the same insurance company that we use, which has nothing to do with what this whole paragraph is talking about. And my concern is how that is interpreted by the people filling that out. For instance, if my spouse was a town employee, I don't get that out of this paragraph, that I would have to disclose that, because I'm reading, this whole paragraph is referencing a 5% legal equitable interest and other things. So I don't know, maybe Kevin Delaney, you could chime in on that. That was my interpretation of it.
I interpreted it in the interest of complete disclosure, even if it's disclosing more than necessary. I put my wife's on there. Mm-hmm. We don't, she is a municipal employee. We certainly don't own 5% of another town. Right. But I put it on there for the fact that if there was ever a question, I would rather say I disclosed it and didn't need to, rather than have the question of why didn't you disclose it? That's just my conservative nature.
Right, but the question's not asking specifically about, you know, like a town employee. You can have everybody reading this and interpreting it. I mean, you know, you interpreted it your way. It's like, well, let's do with everything. You might say, well, it's applicable here because, you know, working for an insurance company has nothing to do about a partnership or 5% interest and things like that. So I'm just wondering if we should clarify that a little more as far as giving someone an opportunity to write what the conflict is, you know, like just different from that paragraph.
I think I understand, and we did touch on this last time.
Yeah.
From your perspective, it would be clear if it just said, what does your spouse do for a living or for work, or who's their employer? And I understand what you're saying is you want to give them an opportunity to, you know, identify a conflict. I think one of the points Jeff made earlier is, you know, this statement is just a very snapshot in time. Who knows what business is going to come up with the town that, you know, may or may not be implicated. I know no one's going to be able to think through every scenario. But I guess if you just listed your spouse's employer, is that what you're suggesting? Because certainly it could be written more clear to state that.
Yeah, just the employee, that could be a conflict of interest. Because what if somebody, you know, they interpret it the way I'm interpreting it, they don't put down spouse as a town employee. Then something comes down and they said they didn't disclose it. Well, you know, that was their interpretation of it, that, you know, how can they be held by not putting it because of that interpretation?
Yeah, very good point. Very good point. And that's why it's my opinion that this should be as least restrictive or as least information as possible that's disclosed, so that those issues don't come up, you know, that, hey, you didn't disclose this. It's like, well, I didn't know that's what it meant. You know, and they obviously, again, I'll go back to, there's already a requirement to self-report, so to speak, if any issue arises. And then, it's got to be clear. People need to know what they have to disclose, and it should be as, the least amount of information as possible that still gives public confidence in the town's dealings, in my opinion.
Right. Well, that was just where I was, because I just think that that number 3 is going to be interpreted different ways, and if you're going to hold people liable to have something, you can't. I mean, you can't just say, well, you should interpret it this way because
Yeah, I agree with you. It's not a very clearly written paragraph, and my guess is it came from some boilerplate or stock form that the town grabbed onto when this was being put in place.
Well, that's just my recommendation. Stay with this, including that specifically, or even a statement that is signed that I received ethics policy, or putting it elsewhere. I don't know. Just in general, if spouse or dependent, is employed wherever, as a town employee, any conflict of interest, a general statement doesn't fall under, in particular with partnership and 5% equitable interest and all that, because that's a whole different ball game to me. That's all I have.
Okay, thanks, Sue.
Yep.
And my guess is, Jeff, tell me if I'm wrong, that union leadership's not going to, there could be no sort of negotiating or finding out what they would agree to outside of the collective bargaining process. In other words,
That's right. Yeah, I mean, the contracts, unless the contract's open, they're not going to bargain for anything.
and I think it might be Anne Marie that brought this up last time. One thing that is problematic is this policy gets enforced, in a manner that's not equal to the people who are supposed to be submitting these financial disclosure statements.
Right.
Nina, any particular thoughts on whether you think we should recommend that the financial disclosure statement, stay in place, or we, recommend that it be abolished, so to speak?
I don't know. I'm torn as well. I mean, when you read the ethics policy, I think the statement of financial interest defines more what the ethics policy is requesting. So I'm thinking maybe we could eliminate the part on number 3, employer, where it says at least 5% of legal equity, $10,000 earnings. Maybe that's scaring people a little bit, because now they feel like, oh my goodness, I have to disclose, my wife is working for the town and I have to disclose her salary. No?
Yeah, good point. I mean, maybe it's simpler just to say, list your spouse's employer.
Right.
Or business they own.
Or a business they own. Or a partnership.
So kind of combining the two, what I was saying and what this paragraph is saying.
Say that again, Sue?
So you're kind of like combining the two, like disclosing a business or corporation, and then also disclosing your spouse and dependent's employer outside of any business. See, I'd like to see it kept separate, though. Because, you know, when I look at that, I'm thinking, you know, the corporation is your employer, but
Kevin, I know you weren't in this position when this policy was adopted. And maybe Kate knows. Was there a financial disclosure requirement before the town adopted this part of the ethics policy? Okay, so it just came into effect a couple years ago or a few years ago.
There was always a requirement through the charter and through the statute, but there was no, you know, to disclose any kind of conflict. But there was never the financial statement until this was adopted by the town council through the recommendation of the auditors.
Okay, so the policy language existed to self-report, so to speak, but there was never any requirement to submit in writing any information to the town.
Correct, and there was never the ethics policy. It was only through the charter and no, it was just a charter and any statutes.
If I can insert one other thing, this is Kevin Delaney. One other piece of information that people have given as feedback from the union is a concern about disclosing a lot of information on something that they perceive as being subject to freedom of information. So in other words, it's not just disclosing for ethics, but that it could be subject to someone taking it. I did bring that up with our auditors, and they were of the impression that this is one of the exemptions that's not covered under FOI and would not be FOI-able. I don't know. I'm not certainly not an FOI expert, but I think to the extent that this information is not subject to FOI, that might help move people along a little bit better if they know that the information is not subject to public disclosure because somebody requests it.
Thanks for that information. And I think the problem with that is, who knows? You're never going to know that until the Freedom of Information Commission makes a decision. In my opinion, it's like, in other words, it's going to be hard to say to the union, don't worry, it's not going to get disclosed. And then there's an administrative request for the information, and the commission who handles that, feels differently and says, no, that's, you can get that information under this request. So I think the unions would know that, but maybe I'm wrong. Do you have any thoughts on that, Jeff?
Well, I don't think it's exempt. There's an exemption under FOIA 1-210B is the statute that deals with personnel records if the portion of the personnel record that you want to exempt is considered to be an invasion of privacy. So this comes up all the time. People think that personnel files are exempt from FOIA, but that's not the case at all. But if you have somebody's performance review, it's subject to FOIA, but if there's something in that performance review that subject to a reasonable community standard would be considered to be an invasion of privacy, you can redact that portion of it and argue about it at the FOIC if somebody files a complaint about it. But, there's nothing that would be disclosed in the context of a financial disclosure that would be, personal identifying information. Nobody's giving a social security number. Nobody's giving a tax return. Nobody's giving a driver's license. Nobody's giving any, information about minors. Nobody's giving any security sensitive information or anything else that's exempted by federal law or any of the exemptions in FOIA. So I do a lot of FOIA stuff. I don't think it would be an exempt record under FOIA. I fill it out. I don't have any concern about it. Kate sends it to me. I send it back to her the same day.
The unions, that is their sort of bargaining period staggered? In other words, they don't all happen at the same time, right?
Yeah, I don't. You know, Kevin Roy from Shipman and Goodwin is the town's labor council. I don't have a list of the expiration dates for the bargaining unit contracts. Maybe Arosh has a better handle on that, but they're staggered. Yeah.
We just completed 3. Well, 1 is almost complete right now. We have another 2 coming up at June 30, 2021. They'll expire. So we'll start working shortly on another couple of them. But they typically run 3 or 4 years in length.
Okay, so you'd be, in the event that this could be agreed to by union and management, it would be several years before there was a uniformly enforced policy.
Correct.
Kevin, this is Arosh. I'm just trying to think about there's a lot of feedback here. Practical application of this. So let me give you this example. Let's say everybody agrees to disclose where their spouse is working or the businesses that they own. And someone who works at the Timberland Golf Course says, my spouse owns 5% of this business, discloses it. They might even not know that the highway department goes out on a bid for a contract and end up doing business with this spouse's company. There's no one's checking that. So what is the real value of that? I mean, they might disclose everything, but what's the practical application? We just go in and do the business, and the spouse who works in another part of the town might benefit from it without even knowing about it. We don't have a system in place right now. Every time that we go out to bid, that we take all the employees in the town and see if they are actually working at any of these places, and nobody has the time to do it, and that's not practical. So I'm wondering whether we are trying to do something that's not really going to add any value. But that's a financial disclosure piece. As far as the ethics policy, I mean, I find it hard to imagine that somebody's going to say, I'm going to be unethical, right, in anything that they do. So I think, Jeff, you mentioned this before, that regardless of whether they sign it or not, that doesn't preclude them from not complying with the ethics policy. We could put some language in there saying, as a employee of the town, you are subject to this ethics policy. That I'm not concerned about. Who's going to do something unethical and say, yeah, I didn't sign it, so I did something unethical? That's never going to work. So I'm just going back to the financial disclosure. I'm really trying to understand the practical application in, if there's a better way, if there's even any value at all, asking people to sign it, except for like top managers and people who have real purchasing authority, Director of Public Works and myself and Kevin and HR Director, and real people who have buying power who actually sign off on things. Others, yeah, no big deal. I'm just throwing this out for everyone to chew on it.
I think that's a really good point, because like you're saying, we're collecting all this information, but we're not doing anything with it, right? I mean, we're not following up and following through with it. So what's the point of gathering all that information? Is that basically what you're saying, Arosh?
Yes, that is what I'm saying.
Yeah. I mean,
Yeah,
Yeah,
agree as well.
I tend to agree with that. I mean, I guess the information being on file, could be the catalyst for someone to request it and say, hey, wait a second, this person has a conflict they didn't disclose. But, again, I think that it just might be overkill given the language of the charter and the other parts of the ethics policy. And it is concerning that it's not going to be uniformly enforced, that it can't be because of, particular union's positions. And they might be right, they might be wrong, who knows? But the fact is that in practice, they're not, we're not getting 100% compliance because of this. So, obviously it could engender bad will. Why do I have to comply and they don't?
Right.
And I would add, all of the top managers who are non-union, they will sign it. That's a non-issue. There's no union telling them don't sign it. I mean, folks who are the head of IT or finance director, myself, public works, they don't. They might have to look for employment somewhere else. Hate to be harsh about it, but I mean that's what you sign up for when you become a top level manager.
Well, that's the other, if I could, Mr. Chairman, that's the other issue is there are ways to deal with this. You could say, hey, we want whenever someone's appointed to a board or commission, we want the town council to make as a condition of their appointment that they sign this. We want the town committees, when they have their nominating conventions, we want them to make as a condition of the nomination that the candidate understands that if elected, they have to sign this. So that deals with the elected and appointed officials. It still doesn't resolve the issue that you've hit on, which is the inconsistency between bargaining units and non-bargaining unit employees as well. We're never going to be able to resolve that, no matter how diligent Kate is, and no matter, the elected boards and commissions in some ways are easier because we can deal with them through the town committees, and we can deal with them at the time of reappointment. We can deal with them at the time, the chairs of the boards and commissions can be tasked with following up with their own members. So there's ways of dealing with the board and commission members, but the town employee part of it's the hard part.
And Arosha, are those the sort of categories you just identified? Are those all management, non-union positions?
Yes, they are, and they are the ones that have real purchasing power and do the big ticket items. We are not going to see someone who's working in not to make light of these positions in animal control or building department for that matter, making large purchases. Right? And I think we also have checks and balances in terms of the bidding process, and everything over 10,000 going to the council. So there are multiple layers of review and checks and balances that happen. Not to the extent to go and see, we might be doing business with a company in Massachusetts and we have no idea if any one of our employees or their spouses have ownership of that company. That we will know. But for example, if I'm signing off on hiring a consultant to do some work for the town, and if I sign off on that I'm, or someone in my family is going to have a financial gain by engaging that consulting firm, that's pretty much grounds for termination. That's what I'm saying, just knowingly doing something like that. So that conversation can be had with the 8 or 10 people who have real purchasing power, and they'll be signing off on those documents, ethics policy and the financial disclosure.
Okay, so just to ask the other members of the board, so that's a recommendation to have sort of a hybrid policy where the non-union management with the purchasing power, elected officials and board appointees are required to sign, and submit a financial disclosure statement, which I guess can be combined with just the general other employees in town getting the general letter that is sent by the town clerk saying, here's the town ethics policy. Maybe even highlighting if the town attorney says this is okay. Here are the sections that require you to identify any conflict of interest. And here are the potential penalties if you don't.
That's fine.
I think this is Sue. I think that might be a better option than sending it out to everyone. The select people would have an impact on it, with purchasing power. Probably town council members because they vote on if I'm correct. And then that would also probably be more manageable for Kate through.
And that's all that really matters, right?
What's that?
Nothing.
Yes.
If I may,
Sorry, Sue. I was a poor interruption. I apologize.
That's okay. Now, just to sum it up, I'm saying that might be a better option just to have the core people that have the purchasing power complete that statement of financial interest. And then that would be more manageable for Kate, too, to have a, less amount to have to follow through on them being returned as well. That's it.
if I may, Chairman, one more, and Kevin, you can correct me if I'm off on this one, but I think most even union employees will be open to signing something that says they received the ethics policy. I don't think we'll get pushed back on that. They might, I think they don't want to sign anything that says they're going to abide by everything that's in there. But acknowledging the receipt of the ethics policy, I'm pretty sure they're open to it. And I could be wrong, Kevin.
I would agree. I mean, and plus I'm not sure how they could say they're not willing to sign something that says, I received this document. You don't even say you're agreeing to it. You're just saying I received it. It'd be hard to, I'm not sure what argument they could make to say, I don't have to do that.
Right. And if someone did and that was brought to the commission's attention by way of formal complaint, it would be dealt with that process. Okay, so that it seemed anything else on that, Nina?
No, I agree.
Okay. Anne Marie, any thoughts on that?
No, I agree. I think that sounds like a better situation. Put it up that way if we could.
So then, if that's our recommendation, I think the next step would just be to decide what revisions you all think are necessary to the financial disclosure form. Obviously, I know we've had a couple meetings now where number 3 came up.
Yeah. Either clarified in some way or added regarding employment outside of any type of a corporation.
Kate, when's the next town council meeting?
December 15th.
Okay. What's the best process for us to make requested revisions to this policy and statement? Is it to stay in this meeting and do it in session, or is there other ways we can do it?
It's a public, it's open to the public, and the public has the right to know what you're thinking. I mean, you can direct there's a lot of background noise But you can direct the Corporation Council or myself to come up with some of the things that you're suggesting. What I'm taking away so far is with the Exhibit A, that you want to remove that last part of the sentence, and I agree to abide by the requirements of the policy. And then in the Section 1-10, Statement of Financial Interest and Filing Requirements, that it would be all elected officials, top management. Do you still want to include the revenue collector, assessor, and purchasing agent? Those three are in a union. So we could remove those. I will also say that all three of those report to the finance director. So there is, probably an oversight to them because of the finance director. So if we say all elected officials, top management, then the question is, do you want the members of the Board of Assessment Appeals, Board of Ethics, Corporation Council to continue?
Yeah, other members. So the town attorney recommended, or at least said an option is to have all elected officials and board members agree to this. I guess that would take some doing because you're looking forward to anyone who wants to be nominated to have to agree at that time as opposed to currently elected people.
But not all board and commission members are required to do a financial statement.
Okay.
The only ones that are required to do a financial statement is the really the Board of Ethics. It's really the Board of Ethics at this point. All elected officials are supposed to do it. So that would be the town council, the Board of Finance, the Police Commission, the Board of Assessment Appeals. Anyone who's elected is supposed to do the financial statement. The ones who are not included in the election officials would be the Board of Ethics, Corporation Council, and I guess you can continue with the other town employees as the town manager, so they'll designate if you want to. Because the Board of Assessment Appeals is elected. Then on the financial statement, if I understand what you're thinking, is to almost maybe make that separate that out, where it's clearer that you're asking about the spouse or the I suppose spouse, your spouse as far as the employer, and if you have any outside employment. I don't know if that's too simple, but.
Could it be separate from number 3? So it's not thought of as part of that?
Okay. Do you want to change it, Sue, to like say employment and have one, like 3A, the employer of your spouse, and 3B, if you have any outside employment? Or it could be numbered.
Yeah, as long as it specifies that it's employment that doesn't have to do with the topic that the paragraph is discussing.
Yep.
I mean, the whole paragraph is discussing, corporations and partnerships and things like that.
Yep. Jeff, is it appropriate if I email you what I think their changes are?
Yep.
And you review it?
Yep.
And then at that point, we can send it out to the Board of Ethics for their review, and then they can vote or change it or whatever they want to do at another meeting?
Yes, that makes
Okay.
sense.
Kevin, are you comfortable with that, Mr. Chairman?
Yes, I think that makes sense.
Okay.
I think that would be the most efficient way to do this.
Sounds good.
Is there anyone else who has questions or thoughts? Cool.
I'm just looking at this quickly now, so I'm not sure, but the ethics policy itself on page 7, where it says a town employee or public official shall refrain from voting upon, otherwise participating in any matter on behalf of the municipality if he or she has a conflict of interest defined in section 1-1E of the policy. So I'm not sure if that 1-1E is referencing the financial interest statement, but we may have to look back through the ethics policy to see if anything is reflected in here that with that statement, if it has to be changed.
I think that it's a good point. We should definitely make sure that we know everything that we're changing or have to. I believe that particular section 1-1E just defines what a conflict of interest is.
That's right.
Mm-hmm.
But good point, Sue, that we're going to have to make sure that if we
Yeah.
change something, we know that it doesn't alter some other section somehow.
Right, yeah, I meant, yeah.
Do you have any questions, Kate? Or do you think you have a handle on what the suggestion is, or do you need any more info?
As I stated, that's what I think that you want to do. So I can definitely, like I said, review it, send it off to Jeff, have him review it. He has a much better way of the language than I do, and he might change a little bit, and then we can send it out to you. It's just that and there's nothing wrong with sending it out to the board, but you can't vote on it or have any kind of conversation about it.
Right, we have to get back in session and do it in a public forum.
Right.
Yes.
Okay.
All right. And the only problem I really have that I'm going to say is I don't have any of these well, especially Exhibit A is no problem, but I really don't have these documents in a Word document. So the other thing will be having to retype everything.
I think I do. Can I send those to her, Jeff?
Yes, that's fine.
Did I send them out to you in a Word?
I believe so, but it might have been in the past. But I have them up right now in Word, both the charter and the ethics policy.
Okay. All right. If you have them, then I probably have them someplace. I'll look for it.
I guess the only other thing to the members is, you know, if the recommendation, it sounds like, is going to be the policy stays in place to some degree to certain members of the town. What do we want to do about that notice requirement? The second notice, which seems to be, I don't know, ambiguous or has no teeth to it.
Are you asking to discuss that now, what the recommendations would be, Kevin?
Yeah, yes, Sue, thank you.
Oh, let me go back, let me find that section.
I think it's 1-10D.
Yeah, it's on page, well, in here, if they fail to wait a minute.
Can I share this?
Yeah, this is it. It talks about finding the supervisor.
I don't know if anyone's able to see what I just tried to share.
Yes.
Okay.
So from this, it looks, Kate would have to, who has not returned it, I guess, failed to comply. And the first step would be notify the supervisor. And if not complied within 30 days after the second notice, the individual will be called to the desk. So I'm not quite following this.
Yeah, I think our,
Time as sending out second notice.
yeah, the issue we've discussed in our last meeting or two was that, you know, is that second notice sufficient? Is it, you know, if someone's supervisor or head of commission they're on is notified, is that sufficient notice for this person to be on notice that they are still in non-compliance with this policy?
Honestly, I don't feel comfortable with that because, I mean, you can have a supervisor, but you have control over how the supervisor does it. You know what I'm saying? I mean, you bring in another, and you're depending on that party. And someone might turn around and say, my father never told me. You know, it's the verbal thing. I think personally a notice should go out immediately, type of grant to know that it was, whether it's certified or something like that. And now we might be talking of lower numbers. I don't know, anyone else have ideas?
So you're saying the second notice, can everyone hear me?
I can hear you, Nina.
Oh, okay. So you're saying that the second notice should be sent certified? Is that what I'm understanding? I'm having a hard time sometimes with outside noises.
Well, you need some kind of format where you know who received it. If someone's going to file a and that the person never returned it, how do you know that they received it? If they signed for it, you have the return signature. They actually received it because they had it. So that's your document that they received it. There's no question about it.
So is the question that how is the second notice going to be sent out, or what exactly, or how should we enforce this? Is that, I'm not understanding, because, you know, if Kate mails out these forms and then it's time to send out the second notices, I think the second notice should go to the supervisor and let the supervisor give the forms to the employee or the manager.
Well, I think by bringing another person, then you're involving someone else. You have to follow up with them, you know, like, when did they do it? Did they actually?
Either that, or if everyone has an email, send them out email and make sure you click on return receipt. The minute they open the email, then that's validation that they received the forms.
Yeah, we need something that we know that they actually received it. Well, maybe that's something Kate and the attorney can weigh in on as to the best policy on that.
I'm happy to email it if I don't get it from the first time, but some people do not have email, and I know that's hard to believe. But as we work through all these different things, I still have people who do not have email. So if you want to add something in there where a second notice to be sent within 30 days by email, and if no email exists, then by certified mail.
Well, I'd say as long as there some kind of response with the email, knowing that they received it, like Nina was saying, like a receipt, email receipt.
Yeah.
And I understand that.
Mail, that's going to be a lot of work.
Well, like I said, some people don't have emails. Or I don't have it, one or the other. So I would like to, if you're going to have me.
I mean, you have personal addresses, right, Kate? I mean, to me, certified mail return receipt requested makes sense.
At least it's another option if you want something. There is an awful lot of feedback in this meeting. I can do it by, email and request a receipt. That's fine. But as I stated, some people, or they have not shared their email with the town. So I need another way to get in touch with them, whether it's by certified mail or somehow, is what I'm saying.
Would it be possible that for this year, when these forms go out, well, I believe they already went out, but maybe have a letter go out in the next 30 days or 2 months that says, okay, from here forward, it is your responsibility to submit these forms annually. And they have to sign this letter, or, like, okay, receipt of letter. I know it's another form, but then from here forward, it would be their responsibility. You would still send out the forms December 1st. However, let's say for me, if I don't receive it within 15 days or 30 days, then I would contact you. It would be my responsibility to contact you and say, I did not receive the forms. Can you send me another copy?
I would like to put that onus on other people, but people get caught up in their lives, and most of these are volunteers. I don't think that onus should be on them. I mean, it says in the policy that they're supposed to get this on a yearly basis. Nobody's reading the policy. So and even people who normally receive this and sign off on it, then they don't remember that they're supposed to do it a year later. Not that I want more work, but I think that you have to send them out some kind of notification as a reminder.
Okay.
I love the idea of what you were trying to do, but I don't think that you'll have any compliance at all then. And it would just be innocent. I mean, they just won't remember. Or you have new boards and commission members coming on. And that's usually when people come into the office to be sworn in, is my golden opportunity to hand them over the Exhibit A and the financial statements if needed, and the policy. Some of them sign off right then and there. Others are like, no, okay, I need to bring it home. I mean, based upon what is going on right now, because it hasn't changed, I've asked that everything be submitted back to me by January 1st. Anyone who has not submitted as of January 1st will be getting another letter on January 2nd. And that's the 30 days, because I had to send them out by December 1st. So,
and then they have 30 days after that to submit the forms, correct?
And then I'm sending the Board of Ethics the whole list. I'm going to tell you who was good and who was funny. It's later than it's after Christmas. So So,
Yeah, I mean, to me, that makes sense, sending out a certified letter, and then you either get compliance or you don't, and if there's non-compliance in a complaint, then the Board of Ethics, goes into action.
so does everybody agree that for the second notice, if the individual continues not to comply with the requirements within 30 days, it says after the second notice. Does it have in here where the second notice is sent out?
No, because I don't think there's any real sending of anything out. I think the town clerk is charged with just contacting other people at this point, right?
Yeah. So maybe we need to add language in that says that, after 30 days of crickets and hearing nothing, that the town clerk sends out a second notice either by email requesting the receipt or by certified mail.
Okay, and then if you don't hear anything, what happens after that?
Well, that may be where this part has to be changed a little bit, where under 1-11,
Kate, you and I will come up with some language that makes sense.
Okay.
That we can recommend to the commission.
Okay, that makes sense. Any other feedback or comments on this particular agenda item, members?
I have one more comment, Kevin.
Go ahead.
On page 9, continues on to page 10, section 1-10B, it does have in there, so this is where we have to be careful, the language that I believe appears in that question number 3.
Yeah, I see that, Kate.
Yeah, statement of financial interest, right?
Yeah, so that's where we'll need to go back and forth a little bit and make sure, as Sue and Nina and everybody else said earlier, that we're not causing a conflict in another section. I'm just pointing that out because I saw it.
Yep.
Yeah, we got to probably read through the whole ethics policy for that.
Yeah.
Yeah.
So in that case, I don't think anybody should anticipate that this is going to go on to the council for the December 15th meeting, because you're going to have another meeting and there has to be some more going through.
Correct. That makes
Yeah,
sense.
I agree.
Do you want input on good dates for the next meeting now, Kate, or do you want to wait on that?
Oh no, let's play.
Okay.
So I just want to let everyone know, I might run out of battery, all of a sudden die out.
Okay, we'll have to call Anne Marie into action.
Yep, that's right. Let me set my bed.
I'm sorry, Anne Marie. What are we avoiding Wednesdays?
Nope, I can do usually Tuesdays and Wednesdays I can do. If we're doing in December, the only Tuesday I'm looking is the 22nd. But I'm usually off Tuesdays and Wednesdays.
Would the 16th work for everybody?
Say that again, please. Would
the 16th, Wednesday, December 16th work? my thought process, it gives Kevin and I a chance to go back and forth. Gives Dana a chance to do the minutes so that we can review to see if we missed anything. We can also then forward the Board of Ethics, what we think are the changes. Jeff, would that work for you?
Yeah, it's fine.
That works for me.
That works for me.
That's fine by me, Kate.
Is 6 p.m. okay for everybody?
Yes.
Yep.
All right. Are people comfortable with the WebEx?
Sure.
Yeah, this is great. This makes sense.
Yeah, I have to figure out why I had a problem.
Yeah. You know, Nina.
Yes, Kate, can Sue and I have a practice run with you at a
You know
later
what?
time?
Yes, definitely. And I think that's a great idea. I'll set up a meeting. We'll talk about when we can do it, and we'll just do like a play. You know, I'll
Right.
send you out an agenda, and you log in, and then you can. And if there's any problems, we can work through them. Definitely,
Okay, great.
definitely.
I think it has to do with the security on my computer, so I'll I'll have to play with it a little bit.
Okay, great. Thanks, Kate. Okay, any other input or comments on that agenda item? Okay, so we'll reconvene the item on the next meeting. And number 3 on the agenda is just approval of our November 17th, 2020 minutes. Any move to approve those minutes?
To accept the minutes for November.
Any second?
I second the motion.
Okay, all in favor, say aye.
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 Okay, so those meetings minutes are approved. Jeff, Arosha, Kevin, we really appreciate your time tonight. You helped us out a lot, so thank you.
Sure. No problem at all.
And we'll see. We'll wait on the email from UK and get back to you at the next meeting.
Great.
Okay, any motion to adjourn?
Motion to adjourn.
Second?
Second.
All in favor?
Aye.
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 Okay, thanks, everybody. Have a good night.
Thank you. Have a good night.
Thank you.
I don't know how we get